This week, the president signed 10 executive actions, none were revoked, and there were 23 updates to active lawsuits. Key themes this week involve national security, immigration, and personnel management within the government. Several departments are impacted, including the Department of Defense, Department of Energy, and the Department of Homeland Security. Notably, several executive orders amend or supersede previous orders related to nuclear reactor technologies and the scientific integrity policies of the previous Trump administration. Among the executive actions, President Trump signed into law Senate Bill 146, the Tools to Address Known Exploitation by Immobilizing Technological Deepfakes on Websites and Networks Act, also known as the Take It Down Act, which criminalizes the intentional disclosure of non-consensual intimate visual depictions and requires platforms to remove such depictions. A proclamation declared May 22, 2025 as National Maritime Day, celebrating the U.S. Merchant Marine. An executive order aims to restore a gold standard for science in the federal government, emphasizing transparency and rigor in federally funded research. Additional executive actions focus on reinvigorating the nuclear industrial base, reforming nuclear reactor testing at the Department of Energy, and reforming the Nuclear Regulatory Commission to promote nuclear energy development. An order was issued to deploy advanced nuclear reactor technologies for national security purposes. The president also proclaimed May 2025 as National Physical Fitness and Sports Month, Memorial Day as a day of prayer for peace, and recognized World Trade Week. Turning to the courts, in JOP versus U.S. Department of Homeland Security regarding Alien Enemies Act removals, the Fourth Circuit denied the government's request for a stay pending appeal. In Jane Doe 1 versus Bondi, concerning other habeas and removal actions, the court issued a nationwide preliminary injunction blocking the government from arresting, detaining, or deporting over 4,700 international students whose F-1 visa statuses were revoked. In DVD versus U.S. Department of Homeland Security, relating to deportation to a third country and torture prohibition, Judge Murphy of the District of Massachusetts has been actively involved. The court has ordered the government to maintain custody of class members being removed to South Sudan or other third countries and ensure the feasibility of their return if removals are unlawful. Judge Murphy found the government violated a preliminary injunction by deporting individuals to South Sudan without allowing them to assert claims under the Torture Convention, issuing clarifications and remedies. Judge Murphy also granted a preliminary injunction requiring the government to facilitate the return of OCG to the United States. Regarding challenges to the removal of independent agency leaders, the Supreme Court granted the government's request for a stay in both Gwynne A. Wilcox versus Donald J. Trump and Kathy A. Harris versus Besant. In LeBlanc and Felton versus United States Privacy and Civil Liberties Oversight Board, Judge Reggie Walton issued a summary judgment for the plaintiffs, challenging their removal from the Privacy and Civil Liberties Oversight Board. In State of New York versus McMahon and Somerville Public Schools versus Trump, Judge Myung-Joon granted preliminary injunctions in both cases, challenging the dismantling and restructuring of the Department of Education. In U.S. Institute of Peace versus Jackson, Judge Howell granted a summary judgment for the plaintiffs. In American Federation of Government Employees, AFL-CIO versus Trump, Judge Ilston granted a preliminary injunction halting the Trump administration's implementation of widespread reductions in force and agency reorganizations. In Wiatkoswara versus Kari Lake and Abramowitz versus Lake, the District of Columbia Circuit en banc declined to reconsider the panel's decision to stay Provision 1 of the District Court order regarding the reinstatement of Voice of America staff, concerning governance and defunding global media and global internet freedom. In Citizens for Responsibility and Ethics in Washington versus Department of Government Efficiency, the government appealed to the Supreme Court asking for a stay of the discovery order. In Agalvis Sanguino versus Noam, concerning Alien Enemies Act removals, the government appealed to the Fifth Circuit, which issued an administrative stay pending appeal. In Darwin Antonio Arevalo Milan versus Trump, Judge John Holcomb certified a class of non-citizens and granted a temporary restraining order. In Espinoza Escalona versus Noam, the plaintiff submitted a notice of voluntary dismissal, and the case was closed. For full details on these executive actions and court cases, please see the 47 POTUS app. This summary was created by 47 POTUS and narrated by an automated voice.